the 5 co-accused charged with helping Thabo Bester break out of prison, well, they are back in court today. They're going to be continuing with their bail application in Bloemfontein. Let's get the latest now from Silindelo Masikane, senior reporter, following this for us. And there you are. It's almost your natural environment these days, isn't it, Slee? On the steps of the Bloemfontein court, and it's all going to get underway a little bit later as well. I just get the sense that this bail application is dragging on a little bit. Maybe you can help me understand why that is. Good morning.
Good morning, and we are of course at the Bloemfontein Magistrates Court, where we are expecting the bail proceedings, like you said, of the 5 co-accused in the Thabo Bester escape saga who have applied for bail to continue with those proceedings. It may be taking a bit of time because of course we have at least 4 different lawyers for the co-accused, and of course we did see the state leading their evidence in chief in opposition of the bail proceedings quite at length, pinpointing how each of the accused has been implicated in this escape saga. But just to unpack the bail proceedings, I am joined by by a legal expert, that is Mr. Marius du Toit. Thank you so much once more for your time this morning. Let's just start with what we're expecting today. Cross-examination will be continuing with the defense trying to, I guess, establish reasons as to why their clients should be released on bail. Perhaps what are they going to have to submit to the court to secure their release?
Well, I think when any person deals with bail, Lee, you have to try and prove, number 1, that your client's not a flight risk. Number 2, that he won't intimidate witnesses, that the evidence against him might not be as strong as the state would like the court to believe. And there could be a number of factors linked with that sort of cross-examination. You might deal with passports, you might deal with my fixed abode, you might want to show that I have a number of properties or I have a business. So the defense in cross-examining the state, because remember, this is a bail hearing, so hearsay evidence is admitted. In other words, the investigating officer can tell the court what he heard another person explain to him or what he heard somebody say. So the evidence that is tendered by in the court is generally speaking quite wide, and you as the attorney has to make sure that the grounds upon which the state is opposing bail, that those grounds specifically are attacked, so that you can show at the end of the day that the grounds upon which they rely are perhaps frivolous, it doesn't carry much weight, and the court should permit my client to bail in the interest of justice. So as an attorney, you are always gauged by the nature of the evidence adduced by the state, because you expect the state to only adduce that evidence which they believe will be sufficient for the court to deny your client bail.
Let's talk about accused number 3, that is Thabo Bester. He, from what we understand from what was revealed by the investigating officer, has a previous conviction, a 2007 conviction of stock theft, where he received a suspended sentence of 5 years. Will this be a hurdle for his bail application?
So that would be a Schedule 1 offence in itself, the previous conviction. So when I'm charged with a Schedule 1 offence and I have a previous conviction of which the record has not been expunged by the court, because certain offences after 10 years can automatically be expunged. If I have a previous conviction and I'm charged with a Schedule 1 offence, so it's a Schedule 1 plus a Schedule 1, it changes my bail application to a Schedule 5. And now the onus will rest on me. Normally, if it's a Schedule 1 bail application, the state has to show reasons why I should be denied bail. If it's a Schedule 5, the onus is now on me to show to the court that the interest of justice permits my release on bail. So it's me that has to do everything now to satisfy the court that I've got a fixed abode, I don't influence witnesses, I've got a fixed address, I'm a South African citizen, I'm not a flight risk, I don't have interest overseas. So there's a number of things that I would then have to focus on. But it's not insurmountable. Every murder case is a Schedule 5. Every theft or fraud above 500,000 Rand is a Schedule 5. And normally, if you look at a previous conviction, you often want to see if it has any correlation with what I'm charged today. For argument's sake, if I have a previous conviction saying that I was convicted of failure to attend in court, well, that will have a material bearing on the fact that I want to be permitted to bail now. But if I've got a previous conviction of 2007 of theft of an animal, cattle or whatever, the reality is I'm now being charged with something completely different. it might be said that, listen, that was a crime that had an element of dishonesty, and hence today's offence is also one of dishonesty, because we're talking about fraud. So you can bring that into correlation and say it's relevant for that basis. But the fact that it's so old, I mean, we are talking about 16 years in the past. I don't think the court will rely much or put much weight on that previous conviction in itself, seen in isolation.
Lastly then, Marius, let's canvass the issue around public outrage. We know in terms of the defense, they are arguing that, there's not much presence outside court. We're not seeing much protest action. In terms of what weight the court will put on public outrage, what can we expect in terms of the magistrate considering perhaps the safety of the accused and perhaps, due to the fact that this is such a high-profile case, perhaps this may not sit well with many South Africans to see the accused released on bail?
It is without a doubt a very important consideration in bail. If the granting of bail could lead to the public outrage and could result in public disorder, it's a factor the court can take into consideration. You remind yourself, Silly, when we had the Bloemfontein, I think it was Bloemfontein riots, and they were charging certain individuals who were later found to be, I think, not guilty by the High Court, but they were charged with murdering a farm worker, and it led to complete public outrage. Now, that was a typical incident where you would say as a magistrate, wait a minute, in light of the reaction that we have from the public, it's clear that I should be cautious in granting this bail because this is the result, this is what could happen. If we haven't seen something similar in the Thabo Bester matter, we haven't seen people picketing outside, we haven't seen cars being set on fire and stuff like that, well then it is a factor to be considered because it hasn't led to public outrage. But I think it's safe to say in this instance, without a doubt, the outrage has been the reaction of a broad spectrum of the lack of controls at this prison, the fact that they were able to escape from a facility which was supposed to be secure. And you and I, as the public, have a right to know that we are safe when these criminals are in prison, that they are kept there. So the outrage is perhaps more in respect of from the political side, more from the public forums, but I haven't seen any outrage in the streets. So is it a factor to consider? Absolutely. Is it the smoking gun to say, now I'm granting bail? Definitely not. The offense in itself is so serious, and the charges are so serious that the court could readily say, based on that, based on the severity of the fact that we are dealing with helping a person escape from justice, that in itself justifies the denying of bail. So I don't think the court will focus solely on that, Slee, but it's definitely a consideration to take into consideration when the court hands down judgment at the end of the day.
Thank you so much for your insights. That is legal expert Mr. Marius du Toit, just unpacking some of what we're expecting to hear in the bail proceedings. And of course, we are expecting those to resume just after 9 a.m. this morning, and we will be bringing you those visuals live here on eNCA DSTV channel 403. Back to you, Gareth.
And also going to be on our website as well, eNCA.com, and live tweets as well from our senior reporter, Silindelo Masikane, as and when she can inside courts. I'm sure we'll hear from you again, possibly just before you go in. But as you say, Slee, court expected to get underway at 9 o'clock this morning as well.